Welcome to the Grateful Life webcast. I'm your host, Ashley Eicher. On today's show, our topic is your blueprint for estate planning with our guest, Amy Cross Nance. Amy is an attorney and lifelong resident of Williamson County, Tennessee. Her practice centers around estates and wills, real estate, and small business law. As a graduate of the Nashville School of Law, she has dedicated herself to assisting her clients through the important events in their lives and the many changes that may come their way. Amy, thank you so much for joining us today. It's so great to see you.
Thank you for having me. I'm so pleased to be here to talk about this very important topic.
Of course, of course. So tell me a little about what is estate planning exactly?
An estate plan is a plan to gather up and organize, a plan to manage your assets when you die, or also in the event of any mental incompetency. It's really to provide for your family when you're gone and to create that legacy.
What are some of the common terms used around estate planning or terminology?
So one of the first terminology of a document is a last will and testament. That's most commonly known. That's a document that says when I die, this is how I want my assets to be handled and dealt with, and the people to handle that for you.
How does that differ from a trust? And what are some different kinds of trusts?
So there are all kinds of trust. The trust that we normally think of that is a kind of an alternate to a will is a revocable trust. That's a document where you create it now, put your assets into the trust while you're living, so the day you die, you don't own anything. The trust owns it, and the trustee already has the power to carry out the wishes. Some other trusts that are involved is a testamentary trust. We can create that in a will or a revocable trust. And then there's irrevocable trust. And there are all kinds of those, and we do that for tax planning or other asset protection.
Why would someone want to create a trust?
So a trust is where you're creating a situation where someone doesn't need the money outright, but we want it held for their benefit for some situation that we're trying to cover in planning.
Right. What about powers of attorney? Because I know there are different types of powers of attorney too.
There are. Powers of attorney are documents needed while you're living, and they're equally as important as those documents that happen when you die. There are several different types of powers of attorney.
So you've got a financial power of attorney.
Yes. So the first one is a financial. That is giving the power to someone to help you pay bills, sell assets, anything that you can do financially.
And then a healthcare power of attorney, right?
Then the other one, which is a distinct difference, is healthcare, and that's to make healthcare decisions and to have your wishes known. The document with that is usually called an advanced care directive or living will. Differs in different states of what it's called, but it says you have the power to carry out my wishes, and this is what I would like for you to do in these circumstances.
Well, and can you go a little bit more into advanced healthcare directives? Like, what does that exactly look like?
So the advanced care directive talks about what you consider as a quality of life. You know, if you're in a coma, you have major physical things, mental things, end-stage illness, what you would consider of just quality of life. Quality of life is very important. And then if you're in those qualities of life, would you or would you not certain treatments, CPR, life support, feeding tube, those kind of decisions.
And the Advanced Healthcare Directive is a companion document, right?
It is a companion document to that healthcare power of attorney. They go hand in hand.
Right. That is so good. That is so good. Tell me a little bit more about healthcare power of attorneys.
So healthcare power of attorney, again, is appointing a person to make those decisions for you and picking who that person should be. It can be a family member, it can be other people. Typically, it's a family member or a trusted friend. Usually picking someone that has that good skill and knowledge to help you make the decision. The medical community is going to give advice of what to do, but they're looking for someone to make that decision if you cannot make it.
Well, and really, that's giving you legally someone who can make that decision for
exactly.
you if you cannot make it for yourself.
And it can be multiple people as well.
Right. What are some of the different types of people that can be involved in that decision?
So it can be a family member, a friend. It can be, other professionals. Typically, your medical people that are providing your care cannot serve that. But if your family member has medical background, they're well suited to be that person to make those decisions.
And in talking about advanced healthcare directives, how do those really work?
So they are in place for your person. So if an event happens and a decision needs to be made, the medical community will go to the person you've appointed, and you are looking at that situation at that time. What is the situation? And trying to think, what is the wishes? Those are hard decisions to make at that time. And having someone to know that really I'm just carrying out their wishes gives some level of comfort.
Like there are so many layers to this. What is a beneficiary designation?
Beneficiary designation is another alternate to will or a revocable trust and transfer of assets. So beneficiaries are things like a life insurance beneficiary, a 401k beneficiary, having a paid on death or a transfer on death designation on account, a joint right of ownership survivorship, like a joint bank account, or owning property, joint real estate jointly with someone else. Those beneficiary designations an automatic transfer according to that designation. And we always want to make sure that those go along with the rest of your plan.
Well, and I've heard that a beneficiary designation overrides a will. Is that true?
Yes, that is true. So
there are so many layers to this, Amy.
There's so many directions to this.
Yes.
So for instance, if you named in a beneficiary of your bank account to be your sister Mary, but in your will you said, I want all of my cash, all my financials to go to my brother John. Well, John doesn't get anything, Mary gets it. The beneficiary designates overrided. So you can see there's going to be some unintended consequences to some of those beneficiaries, so we really want to make sure it goes with the rest of your plan.
Well, and those assets can be structured to be transferred at death, right?
That is correct. That's what that happens. It's an automatic transfer.
Amy, I'm learning things from you. As we've talked over the last couple of weeks preparing for today, I'm remembering some things. Amy's like, sure she is. Sure she is. We'll find out.
There's a lot to learn.
We'll find out by the end of this for sure. Do you have any examples of a beneficiary designation and when that overrides a will?
So it will pretty well always.
We talked about,
it will always override the will.
Yeah.
That if that asset never comes is payable to the estate, so that executor or that trust that doesn't have that asset that comes into it doesn't have any control over it. So that money is completely, or whatever that asset is, gone to that person directly. So there's just some benefit of that. It makes some of it easy, but we want to make sure it is all what you want to happen.
Well, and I think about two examples of like listing a beneficiary on a life insurance policy. Can you provide some more examples similar to that?
Yes, so the beneficiary layman of the life insurance is this life insurance. When I die, pay this money directly to this beneficiary. So it makes it very, very, very easy. One advantage to that is that money is not subject to creditors. Naming a beneficiary on a life insurance makes that money not subject to creditors.
But then when you have something like an IRA or a 401k, what does that look like?
So IRA, same thing, is to pay to those beneficiaries. And if an individual is named as a beneficiary, it becomes an inherited IRA or inherited 401k, and they have 10 years to spread that tax over that time. So again, that becomes their 401k, their IRA.
And then on bank accounts and investments, what does that look like?
So that is, again, going to your bank and telling your bank, when I die, pay this money to these people. So whoever it is takes a death certificate to the bank, and that money is immediately transferred. So it's easy.
What about in something like real estate that is owned by a couple?
So real estate, that's a joint right of survivorship ownership. A married couple, one dies, the property automatically goes to that spouse, no matter what anything else says. Same thing if you have that with another person. Whoever the survivor ends up with that real estate.
Wow, okay. So obviously there's so many different outcomes that you can have when we are looking at these beneficiary designations.
Yes, and we want to make sure that those outcomes are what you do want it to be. Like on a joint bank account, sometimes a family there may be 12 children, and and one child is helping a parent with paying bills and that sort of thing, put them on that bank account. That bank account goes to that one child, and the other 11 children are left out. So it's always to make sure that's what you want and not something different.
Right. What about if the beneficiary is a minor?
If a beneficiary is a minor, on that, we do not want that because they are not able legally to manage that money often.
Okay.
We may need to set up a court or a guardianship, a conservatorship, some other. So we want to not consider putting minors as direct beneficiaries.
And then, you mentioned earlier naming who will be in charge. How do you determine who those people should be?
I think it's looking at the different skill sets, the experience, the expertise they have, their availability. Are they able to do the job? And
Right.
can they do this for the length of time that the job is needed? And then a key thing is trust, of who you trust to do this.
What are some of the roles specifically? And then do you need to have alternate people just in case something happens?
Yes, I think you definitely need to have alternates, because in naming people, they cannot serve for some reason. Something happens to them and goes down. So having alternates, maybe a corporate trustee or corporate person at the end of it. But the roles that we do need to fill are an executor under will, successor trustee on a revocable trust, or trustee for trust that's going to last beyond that initial time after someone dies. And then most importantly is appointing a guardian. That's the person to raise the kids until they are of legal age.
And could you dive into a little bit the differences between the two, between an executor, a trustee, and a guardian?
So executor is the one that is managing the estate and getting everything ready to transfer over to the heirs. And that successor trustee in the trust has that similar role. That's kind of a synonymous term. But the difference of the other trustees is there is a longer time. We may say that something is going to be in trust until someone is the age of 40. Well, they've got to manage that for a long time. So that's why the alternates are important to think about, is over time, are we going to have enough people in place?
Is an attorney a good alternate?
And the people that can serve it, an attorney can serve, anyone can serve in those roles.
Yeah.
Like I said, it can be a professional, family member, or a corporate entity. But any of those can be served. So sometimes we want to have some people that may be around all the time at the end of the list.
Well, and should any of these roles be filled by individuals, or should it be groups of people?
It can be, you can have multiple people serving that role, and then we have to think about in the decisions, do they all have to agree? Is it 2 out of 3 agree, or can they act alone? So when you're appointing multiple people, we need to think about all those situations.
No, absolutely. So is it always family members or legal professionals? I know we've touched on this a little bit, but can you dive into that a little bit more?
Yeah, I think it's who you feel is best.
Most trustworthy, yeah.
So legal professionals or other professionals are out there that can do it. The advantage, I guess, of a corporate trustee or a corporate executor is that's something they do every day. They are there, they have great resources, and they're always there. So that is always a good option to consider.
Well, and can you appoint a healthcare professional for your medical directives?
It cannot be someone that is providing care for you.
Okay.
It can be someone that has that experience, but they're not in your day-to-day care.
Now, what if it's a family member who is a medical professional?
It can be a family member, but they probably would probably not be under their care.
When you're thinking about, the differences in powers of attorney and who should fill those roles, like we talk about maybe a financial advisor or an attorney, like if someone's thinking about who might be the best person for me, it really does boil down to trust, it sounds like.
It does boil down to trust, and I think also that availability. Some of those roles, that's the person that's going to be there day to day, helping, to buy pills, to do things, to be able to take you to the doctor, to those things. So availability is a consideration, very important.
Are there any other things just that you feel like these people should be that we haven't covered?
No, again, it really just feels like who to pick is someone that you feel comfortable with. And in family members, they look at, different children. They can be, one person has a different skill set or a different availability than the other, and they may pick different people of it. So it just feels like who you feel most comfortable.
Well, and I do think, too, I know when we've talked before, really thinking about all of this is so important to lay out, because I've heard so many horror stories of these things not being put in order, and then there being fights between family members after someone has passed away, and a lot of push and pull. So have you seen that in your business as well?
I have, and that's what is important. This is your decision, your wish of what wants to be done, and having it laid out, that is what will be done, is what your wish is, not what other people, and having those roles established.
Yeah. Can you explain what the term probate means?
Probate, the actual word probate means prove the will, but we use it in conjunction with saying for the estate administration. So that process is for the will to be submitted to court. The court stamp it, says valid will, executor, I appoint you the power to carry out the estate administration. Estate administration is gathering the assets, paying any debts, and then transferring it over to the heirs.
Yeah. How does that vary from state to state? Because it is different, right?
It varies greatly from state to state. There are some states that process is very, very simple, very easy, and there are other states that it is very complicated, and generally you want to try to avoid that process.
Yeah.
It depends on where you are.
Where would you find that information?
So you would find that information just in general, information you can find and looking, but really you need to talk to a professional. That's that person that really can sit down and tell you and evaluate, know your situation is you're avoiding probate by doing this and this and this, or it's fine not going through a will.
Right. How do you avoid probate, or why would you want to avoid probate?
So the ways to avoid probate are revocable trust, putting assets into the revocable trust. That already gives the power to the trustee to carry it out. And also beneficiary designation, that automatic transfer. And the reasons, why you may want to do it is just you may have property in different states that you don't want to probate in every state, or it may be a hard process to do to make it easier for your family.
What are some common misconceptions about estate planning? Like, I think so often people think it's only for the wealthy or it's only in death. Like, can you talk a little bit about that?
Sure. Yeah, no, estate planning is really for everybody.
Yeah.
Every adult has some assets. We have children we need to provide for, to think about. So everyone needs to have a plan. And if you don't have your own plan, you have one. You don't know it, but you have one. Every state says if you do not say where you want things, this is how your assets will be inherited. And often that is not what people want.
Right. What are some other common misconceptions around estate planning that you hear that you want to dispel today?
I think there's a fear of going through it, that it's hard and time consuming and just you want to avoid it. And really it's not. It's a relatively easy process when you just sit down and go through that.
Well, and you mentioned that it does vary from state to state. And if you don't have a plan in place, the state is going to have a plan in place for you. So
yes, they will.
Where can I go to find the information on my state's estate planning? Say that 5 times fast.
So that's in your state statutes, the laws of the state, and it's called laws of intestacy, one of those legal words there. So searching out to find that information, but that's what it is, laws of intestacy.
And as people are searching for that, is there anything they need to be specifically looking for?
No, those would be the terms that would find that answers for you.
That's great. So when you're thinking about sharing plans with your family, can you talk to us about how important that is and at what time you should do that?
This is your private information, and you don't have to share it with anyone of your family members, but sometimes I think it is good to at least talk a little bit so your family knows what's going on and involve them in some of the decisions. They may have concerns or things that they would like to do. When someone dies, it's a very hard process going through the grieving.
Yes.
So sometimes knowing what to expect and not be surprised is important.
So when you think about kind of going back to what we were just talking about in some of these states where the law is very specific, like if you're married and you have children and your estate gets divided up, 1/3 to a spouse, can you talk to us a little about how that starts to play out?
So those laws of intestacy, a lot of the states says that if you're married, it goes to your spouse and your children.
Okay.
And sometimes people do not want that, and then going to minor children brings up those issues.
Right.
So that's what looking to say, no, this is not what I want to do. And if you don't have spouse or children, it ends up going parents, brothers, sisters, nieces and nephews, cousins. It can get way out there and go, no, I do not want that to happen.
It can get messy and complicated really quickly.
It can.
Quickly. And I know we talked about, some of the myths that you want to dispel is like, is this really expensive? So can you talk about, is estate planning expensive from a practical sense?
Just your basic expense is not expensive. It's and depending on your state and the complexity of your estate, but basic one is not expensive. It's not very time consuming. But the real expense is if something is not done afterwards and trying to redo something or the contest or anything that comes up, it's much cheaper to do it right here on the front end and have it all in order than later.
Well, I know that we were talking on the phone recently, you said, I have clients that are like, if I'd known that it was going to be this amount, I would have done this a long time ago. I feel like there's a lot of a fear associated with estate planning.
There really is. They just feel like it is so complicated and so hard a process, and come through, when we walk them through the questions and the process, they go, well, this wasn't so bad. This was easy.
Yeah. Can you give sort of a range on pricing? I'm sure it varies from area to area and state to state, but
it really does vary from state to state. But generally, I would think under $1,000 a basic plan can be done.
So what do I need to start creating an estate plan? We've dispelled the fears as much as possible,
Right.
but what do I need to get started?
So I think first of all is to sit down and ask yourself some questions. What goals do I want to achieve? Who do I want to leave things to? Are there limitations? What assets do I have? What beneficiaries do I have in place? And kind of think through those things, and then take that information and sit down with a professional that can look at all of those goals and answers and put a plan together for you.
Well, I think, again, it goes back to, like, who do I want to be in charge of that? What is the total value of my assets and debts? Like, those are all things that I think so often finance, for people who are not well-versed in finance, it can be really scary to really, like, get down to the nuts and bolts of. But I kind of think of it as, like, that information is power for you to make better decisions.
It is.
Yeah.
Having the information and knowing what that implication of that information is going to be. A lot of people go, well, I don't have anything. Well, when you start adding up different assets and different things, you say, no, I really have more than I thought.
Yeah. What are some of those categories of things that people may not think about that are considered assets or debts?
Life insurance is an asset. Thinking about other stocks or savings bonds that purchased a long time ago, personal property, collectibles, collections, jewelry, a lot of those things.
How are they structured?
Each asset can be structured in many different ways.
Okay.
So it can have those beneficiaries.
So again, a lot of layers.
A lot of layers, a lot of questions that come up.
This is why it's important to have a professional.
It is very important to have someone to ask the right questions.
Yeah, well, and it's again, it's so much to navigate. So having the right people in your corner that are helping you to make more informed decisions is really helpful. Yeah,
and I think involving a lot of people that you already have helping you with a financial planner, a CPA, of course your attorney, to put these documents together. But gather up all that expertise, and everyone can look at it maybe from a different perspective and put together what is best for you.
Well, and what about if you have concerns about your estate and feel like that's something you need to discuss with certain family members? Do you have any encouragement or advice in helping people to do that in the most effective way possible?
I think it depends on your family situation.
Yeah.
But I think just kind of sitting down and talking about what you feel comfortable of asking. And again, you don't have to do that, but I think sometimes it's good just to involve everyone so they're all kind of on the same page and understand what you want to happen.
Are there other people that, as I'm creating this estate plan, that I should consult?
I don't think anybody other than some of those professionals that are out there. Maybe your banker to be involved.
CPA,
your financial planner, all of those kind of people that you have involved.
Attorneys.
Yes.
All the people we've talked about already. Now, is there anything that I can do on my own online?
So there are a lot of options out there to do that online.
Okay.
The problems that I see with that is, as we talked about just a minute ago, is there's lots of questions. And when someone comes to my office, sometimes their answer to one question leads me off in 2 or 3 different directions.
Right.
And online, we really don't have that opportunity. And we don't have the opportunity. I can look at someone and say, I don't think they're understanding my question, and I can go and explain things more and make sure that they are giving their answers are an informed answer. We never want it to be to say, well, they thought it was supposed to be that and they didn't understand the question. Yeah. So that's online, and sometimes you don't have that opportunity.
Well, I would think too, you don't have the same opportunity to really understand the terminology or context of various situations. And as we've already talked about, there's so many different layers to this. So having someone that can explain every kind of nut and bolt and how it affects this other thing, I think would be really helpful.
Because there's many different directions you can go, and there are pros and cons that have to be weighted and weighed to see what that. Another thing of the online is the execution and the technical things that are involved. Yeah. Every state has a different. There's magic words, there's technical words, there's ways that it has to be signed in front of witnesses, notary, different things, that if that is not done properly, that invalidates the will. So you really don't want to go through this whole process and then it be invalid.
Well, and I would think too, and having an attorney that can really help you execute these things in the correct way is really helpful.
Very helpful.
What are some ways that the attorney can be really helpful in making sure everything's done properly?
Well, they know the rules of their state, of their county, and they know exactly you need to have this done, this notary, this witness, this information, everything. They know those technical things, which that's not something that you would know.
So it really is that the one-on-one with someone that you trust, that as a professional is really important.
It is very important.
Yeah. So what consideration should I take if I'm deciding if a will or a trust is the best option for me?
So in looking at those options and also the beneficiary designation, we look at that entire picture. That, again, revocable trust is avoiding probate something that is good in your state. We may go immediately to that revocable trust. Or is it will is okay. Or is beneficiary designations will work. It really looks at what's your goal and the best method to get that accomplished.
So there are very much three ways for those assets to go to beneficiaries.
There are 3 ways to go. The will, revocable trust, or beneficiary designations, and those sometimes go all together.
How does probate play into all of this?
So probate only happens, that estate administration is if you have the will.
Okay.
The revocable trust and the beneficiary designations are ways to avoid that probate or estate administration through the court.
Because I feel like probate can be a very complicated process.
It can be complicated. There are many steps that have to happen, a time frame of when creditors to file claims. There's lots of processes. So again, it depends on the state. There are many states that it is very complicated, very complicated.
So can you just repeat so we're clear? Because again, so many layers. What is the only way that probate hits?
Probate is when we need to have assets to come through the will. Okay. That will is the document that is saying this is where the assets to be distributed. That we don't have those automatic transfer of the assets through that automatic transfer beneficiary or the trust already having those assets. Those are assets that are in your name. When you die, we have to have the will and probate.
So again, having a professional help you walk through this is really the best option.
It is.
Having that one-on-one relationship. Can you talk about a pour-over will?
I can. So we do a pour-over will in the revocable trust. Okay. In that revocable trust, as we talked about, we want everything to either be in the trust or have a beneficiary designation. But we might forget something, or you forgot that you own some stock somewhere, and to be able to get access to that, we do have to probate the will to get access to that. So we have in the revocable trust a pour-over will, and it's a simpler will which just says, if I forgot something, and we have to do that, we pour it over into the trust, so everything is paid to the trust, and your plan is in the trust. So it's a simpler will.
So again, it's making it very direct.
And it's a backup plan.
Right.
And with beneficiary designations too, a lot of times we want to have a will in place. So pretty well, we always need to have a backup will under any plan.
So really, again, the goal is to keep it out of probate as much as possible.
That is often a major goal and a very concern of people, yes.
Yeah, yeah. How does debt work when you die? Like, I mean, you can't just like sign it over to American Express or Visa at the end and be done with it, unfortunately.
No, I wish that would happen. But no, you die with assets and you die with debt.
Yes.
But debts are only, your assets are the only thing that they're subject to pay the assets. Heirs are not personally liable for the debts, okay, but your assets are. So the sale of assets may need to happen to pay some debts, and that's part of that estate administration process.
Well, and that could really be a mortgage, that could be credit card debt or any other type of debt. Can you give some examples of those other types of debt that may come into play here?
So we may have some, well, of course, We have taxes to deal with.
Good old taxes.
Good old taxes. They do not go away. We have credit cards. You might have some unsecured loans or secured loans of your mortgages.
What if I have a life insurance policy? Would that be considered an asset?
So life insurance is considered an asset for your taxable estate for taxes. But if it's payable, the proceeds are payable to an individual, it is not part as an estate asset. So it doesn't flow into, that money does not flow into the estate and to be there for distribution through the estate. It's paid directly.
Well, and how does that function with debt? Like, can that be used to pay off debt?
So anything that's paid directly to a person, that becomes their money and is not pulled into the estate and subject to debt. So naming a beneficiary on a life insurance policy, an individual is advisable.
So could we take into consideration or really think about what might someone want to think through when deciding who is going to be the executor of their estate? Like, I know it can be a family member, it can be friends. Like, what are some of the skill sets that the person should have that would be really beneficial?
So some of the skill sets is, are they sort of financially minded? Are they, kind of good with money? Have they had experience in dealing with, the type of business? If you have a business, assets, some things that they can step in and do what you are doing yourself.
Right. And again, it doesn't have to be family members. It could be a multitude of other people.
Yes, it can be professionals, corporate trustees. It can be just a good friend.
Attorneys.
It can be attorneys.
We keep going back to attorneys.
It can.
Can you talk, there are a lot of differences and selections that can be made. So can you talk just a little bit about that between like the different types of people?
So the different roles that's involved.
Different roles are like power of attorney, like.
Yeah, so it's again, what is the role that they are going to be handling? So if they're doing the financial power of attorney, financial background of it. Healthcare, it may be somebody that's more care oriented and that sort of thing. Executor, again, say, do they have that ability to gather all this up?
So now, for example, for a financial, because I didn't know this either, for like a financial power of attorney, can a financial professional be selected as the power of attorney?
Typically, by their licensing regulations, your individual person, financial person, cannot serve in those roles by their roles. Now, they may have their firm or other things of a trust department arm of it to serve and help, but they individually cannot.
And what kind of skills should a healthcare power of attorney?
I think a healthcare skills are it's kind of looking after your care.
Yeah.
They're really the ones that's going to kind of be there, during that time when you need some decisions made about your physical care. And again, availability. Are they going to be there when you need taken to the doctor and also those major times of decisions.
And I know we talked about this, but for the medical power of attorney, who are the people that cannot do that?
It cannot be just naming your doctor.
Right.
Yeah.
Your primary care provider.
The medical community is going to give the answers, all the information to that person to make that informed decision and give the background, but they're looking to the person for an answer.
But as long as you have a family member, like let's say I have a family member that's a surgeon or a healthcare provider, they can be the medical power of attorney. They just can't be giving me care.
Yes.
It's a lot. There's a lot happening. There's a lot happening. How often should you revisit or update your estate plan?
So in doing the plan, we think about as many of the foreseeable situations we can in the future and try to cover. But we can't do it all. We don't have that crystal ball. So I advise at least maybe once a year or periodically just to sit down and think about it. Is this still what I wanted to do? But when you have some life event change, that's really when you absolutely need to sit down and evaluate it and possibly make changes.
And what do you consider to be a life event?
So a life event would be the death of someone, birth of another family member, marriage, some new financial assets or some financial change, something that's majorly would change what you might want to do.
Yeah. What are some considerations we should have when thinking about sharing this information with members of our family? Again, friends, people that we trust?
Yeah, so this is private information, but I think getting people involved is very good. We definitely want to let our executor know, or our key family members, where to find these documents.
Yeah.
Having the original is important. And also where to find assets, having an account list, passwords, all those things where they have that access to be able to carry out the job.
Yeah, and I think that's so important because especially in the digital age that we are living in, it is so difficult. I mean, let's be honest, it's difficult for most of us to keep track of passwords and, where different things are. So having some sort of list somewhere and a trusted person knowing where those things are can be really helpful. Do you have any recommendations of keeping that information safe?
So there are different methods of keeping that safe and secure. Everyone's going to have their own way that they feel comfortable of keeping that, but I think giving that where you can access it, your executor can also access it. And we want to give those powers in the documents to the executor to get to those digital assets that we have.
Well, so really it is too like having printed versions as well that are as up to date as possible, that are easily accessible in the event something happens.
Yes.
And someone knowing where those are.
Knowing where they are.
So would you be able to provide a little overview of estate taxes?
Sure. Estate taxes are taxes that are taxed on your taxable estate, the value of your assets when you die. There are federal estate taxes, and there are some states that have taxes as well. So we have to think of the federal and the state. Some states do not have any. But there's always federal. But there are exemptions to that level. Currently, if someone dies in 2025, they can exempt, it's right at $14 million and below. So if an individual has $14 million below, there is no estate tax. For a married couple, it's right at $28 million for a combined use of that money.
Okay.
Those amounts are scheduled to be changed at the end of 2025, so that's something to be aware of that there probably will be changes in those amounts in 2025.
And where does inheritance tax play into this?
That's the inheritance tax.
Okay, that is the inheritance tax.
Yes.
Okay.
Estate or inheritance tax.
So how are digital assets like social media accounts and cryptocurrency handled?
So having the access or for taxing valuation. Taxing valuation is the value of what those assets are.
Yeah.
It becomes that part of your taxable estate value.
Which is so interesting. I don't know that I would have necessarily thought about that. But again, it goes back to, it's important to have people who know and understand this and also know the law and tax law around it.
Yes, it is. So in doing that, if we want to evaluate the risk for the taxes in this estate plan. And the ways that we kind of look at that, there may be starting a gifting plan, a charitable donations plan, or restructuring assets to minimize those tax implications as much as possible.
Yeah. How easy is it to make changes to an estate plan? Is that something someone can do by themselves, or does it really help to like revisit with your attorney once a year to make those changes?
So it's easy to change, but those changes have to be done in an official way. You can't just mark it up and mark it out that it changed. So an amendment to a will is called a codicil. It does have to be executed and notarized by the same number of witnesses, just like the will. So it probably is good to go back to your professional, but it's a quick change. On a trust, it's an amendment to the trust. So it's easy to do.
Well, and if you're changing one thing, is it important to change all of them?
So yes, if you make one change and that's going to affect another over here,
yes,
you need to, again, to make sure that this change is across the board, not disrupting something else.
So if I've changed a beneficiary to one of my assets or the accounts in my will, but maybe I've forgotten to update it on the actual account itself, which one of those takes priority?
The beneficiary designation is going to take priority. That is what it will be.
That's what it will be?
It will be, yes.
To reiterate again, that is what it will be. So again, like we talked about earlier, you said if I leave this property to Mary, but the beneficiary designation says I leave this property to John, John gets it and Mary doesn't.
Correct. That is right. The beneficiary will get that, and it's not.
I'm starting to get it. I'm starting to get all the layers. It's taking us a little bit of time, but it really is. I mean, this isn't something that is necessarily my world, and I know for many of our viewers too, it's a lot of information to take in and try and unpack and figure out what is right for you.
It is. There is a lot of information, and this is not something that most people know. So
Right.
it is looking at the total picture, very, very important. And when you go to one place and they give you one piece of advice and another place for another piece of advice, they may not be looking at the two together. So someone to look at the whole picture.
What about pets? Like if someone has children or has children but has outlived their children, or they don't have any children, like where do pets come into play in this?
So our pets, for some of us, including me, are really family members.
Yes, yes.
And what happens to them is very important. So thinking about someone who is going to care for them, and do we need to leave some money for their care? So all those that can be taken care of in the document too, to consider your other children.
You're sweet. For two-legged friends, four-legged friends. I was like, who are the two-legged friends? As I said that out loud, I was like, wait a second. There's no pets with two legs, right? Anyway, back to estate planning.
Parrots live a long time.
Listen, it's a Thursday. We're near the end of the week. I can't claim anything today. Okay, so if you're making gifts during your lifetime to reduce your taxable estate, can you talk about what that looks like?
Yes. So gifting is, again, part of that plan to reduce your taxable estate. You can give, each person can give to any one person starting in 2025, $19,000 per year without dipping into that lifetime exemption we talked a minute ago. Yeah. But you can also give that lifetime exemption, you can give it during life or at death.
Okay.
So there may be reasons to go ahead and give things, but we want to make sure that we know how those gifts are impacting that lifetime exemption or other taxable things.
And that changes.
It changes every year.
It changes every year. And would that be $18,000 once or like multiple times?
You can be once to one person each year, but you can do it to multiple people.
Okay, got it. So 18,000 multiple times to multiple people.
Correct.
But
one
once a year. Okay. Okay.
Every year.
And then gifts over that time can be made. They'll reduce the lifetime exemption.
Correct.
Is that right? Mm-hmm. Okay. I love. What is the lifetime exemption?
That is in 2025, right at $14 million. Anything below that. So if you gave $1 million away today, then you would only have $13 million when you die.
I'm available for $1 million donations just to make yours too.
Your name and number is.
Yes, my name and number is right here. What about charitable donations?
So charitable donations reduce that taxable estate, and also in your will or trust, if you leave to a charitable at the time of your death, that also reduces your taxable estate.
So what about if you have a joint bank account with your spouse, one of you passes away? Is that bank account subject to anything with the estate, or is it completely in the control of the other person on the account?
So it is completely in the control of that other person. That money doesn't flow into the estate or have anything to do with the estate for creditors or that. But the value of that bank account is countable in your taxable estate for taxes. So there's the assets that come through the estate, and then what the IRS says is your taxable estate. And that's anything you have control over.
So, but often when there are joint accounts, that can have unintended consequences. Can you talk about that a little bit?
It can be unintended consequences.
Yeah.
That you have children. You have one child that wants to help to help with pay bills, and the other children are left out. So we want to make sure, again, those beneficiaries on that go to who you want it to be.
Yeah, and can you provide sort of the specific example of how that plays out if you do have someone that is like let's say there's 12 children in a family. Also, that's a lot of kids, but let's just say there's 12 children in the family. Can you talk about how that plays out?
Yeah. So go to the bank, one child to help pay bills. That one child and the mother, for say, are on a joint account. The mother dies. That bank account money becomes that one child's money. Okay. Those 11 don't get any of that money.
Got it.
And that may not be what the mother intended.
And so and again, one of the misconceptions we talk about. That's why it's so important to structure all of this in the way that you want it to be structured and being very clear about it as well.
Exactly.
Are there revocable ways in structuring that for those 11 other children?
That is when having that money flow into the estate so that it goes instead of to a survivor.
Yeah, to make it, okay.
We want that money to flow into the estate or to the trust.
As much as possible, that's what we want to happen.
Yes.
So what if in my will I left a sum of money to someone else? Is the joint bank account subject to paying that amount out?
It is not.
Okay.
It is not.
And then how does that play out?
So that,
Like, where are some things that you've seen, with your clients for people to be aware of?
Something we have done, if all of the things have beneficiary designations, then there's not any money to distribute it to those that are left in the will.
Okay.
So they are left out.
So let's, for example, say that Terry has a joint bank account with Sam and there's $100,000 in it. How does that play out?
So the bank account is joint with Sam, and in the will it says Terry gets the $100,000 of that bank account. Sam is going to get it because Sam is that joint owner of that account.
Okay. Again, it goes back to like having all of this figured out. And because that with Terry has no other assets. As Terry's will says, I leave $10,000 to each of my 5 grandchildren.
And there's no money that's payable to the estate, then there's no money to pay those bequests.
Got it. So that's all going to Sam.
All going to Sam.
Got it. Okay. So how do you leave a specific amount of money to different parties if you don't know how much money you are going to have in your account when you pass away?
Again, we never know what it's going to be, of that. So the ways that you think about it is there say, I want $10,000, at least of the first $10,000 to go to certain people or something of that nature, and then everything else divided by percentages.
Okay.
Or to do it by percentages. So it's okay that if I have $500,000, I do it by those same percentages, or if I have $5 million, the same percentages works. So it's looking at the what ifs.
What are some special considerations that need to be taken into account when it comes to second marriages or blended families that are a part of the discussion?
I think have to think through that much more than a married couple that's been married for 50 years and have 3 children. So a couple will come into my office and one of their concerns is I want my spouse to be taken care of when I die, but when that spouse dies, I really want some of that money to go to my children. I don't want it all to go to that spouse's children.
Right.
So we think through those scenarios, and a lot of times there we come up with some trust or other that to accomplish that goal where everyone is taken care of and no one is left out.
Well, and I think that happens in so many families. Again, if you have like a grandparent where the grandmother has passed away, the grandfather is alive, that gets remarried, and then trying to figure out where does that money go and how does that work?
Yeah. Yeah, so in that sense, we often say we don't want to leave everything to a spouse and then it kind of eliminate one side of the family.
Yeah. Is there any benefit to putting your house in your child's name?
So adding a child as joint ownership with a child, that makes that transfer of that asset easy. The negative to that is there may be some capital gains implication of that. So when you're making that real estate as a gift,
right,
but you're also giving your basis in the property. So if you've owned that property for 30 years, you paid $50,000 for it, and now it's worth $500,000. Then when it's sold, if you inherit it, you get what's called stepped up basis. The basis becomes the value of death. So an example of that is that if you give property today, die tomorrow, and then sell it the next day, of course it never happens that fast,
right,
is that the child would pay capital gains tax based on your basis of $50,000 and then the price of $500,000, so substantial capital gain.
Substantial difference.
But if you didn't give the property to that and let them inherit it, they get what's called stepped up basis. The basis becomes then not $50,000, but the value as the date of $500. And the next day they sell it for $500. There's no capital gains tax. So considering the potential for capital gains tax has to be weighed.
It's really important. What about placing them on your bank account? Like, is there a way that they can sign but not get all the money in the account like we talked about previously?
So there's a lot of other ways to structure that bank account where it can achieve that goal to have someone to help pay bills. And that would be an authorized signer on that account. And then also that paid on death is an authorized signer, and then when I die, pay it to all of these people. One person sign, but then pay it to those other 11.
Right, which again, the joint accounts has to be considered too.
Yes.
So adding someone to, I'm sorry.
Those are alternates to a joint account, other methods that the financial institution can do.
And what about when adding someone to real estate to make the transfer easier? What does that bring up in terms of complications, or does it?
So again, making sure that's what we wanted, and then that capital gains tax. That same things. Is that capital gains tax going to be there for that person, or do we really want them to get the stepped up basis?
I mean, it's, again, I know I keep saying this, but there is just so many different layers and so many things to consider when we are doing this.
There's so many what ifs and pros and cons to,
Yeah.
There's one decision is not the absolute decision. There are pros and cons to everything, and everyone's situation is different.
Yeah.
There's not one size fits all to this.
So it really does go back to, it's important to have that one-on-one with someone who knows what they're doing and knows the different tax laws and everything that you need to do.
Correct.
I want us to get to the audience Q&A because we have some really great questions. We had so many questions submitted for this particular webcast because I think it is so relevant to our audience and what people are walking through. But before we get to that, is there anything we've missed that you want to make sure we cover?
No, I think we've covered a lot of. This has been kind of an overview of everything, and hopefully it's answered some questions for people. But it is an overview.
Yeah, and obviously, if you have questions, make sure that you are putting those in the chat. We want to get to those. Are there any special concerns when you have property in multiple states, a home in Ohio and a vacation home in Florida, for example?
So if you have property in multiple states, you may have to probate in multiple states. So having property in multiple states is a very good reason to have a revocable trust.
Okay. So, for example, someone asked, I sold my home to move to Brookdale. Do I need a trust or a will?
You may not need a trust. If we look then again to see if all your other assets have beneficiary designations, if that's going to accomplish your goal, you may not need a trust, but I always advise having a will just as that backup plan.
Yeah, just in case. Now, can I handwrite my will?
A handwritten will, again, different states can be proven, but there are many, many hurdles to get over on a handwritten will. So I thought it's best not to do a handwritten will.
I'm going to say my parents have done that once or twice. They don't travel a ton, and it's like right before they travel, all of a sudden I get like photos of a handwritten will, and I'm like, I know you guys have this other places, but it's funny that to me is the thing that they think about, and I'm grateful for that, but it's good to know that there are hurdles with a handwritten will.
There are.
Yeah. Okay, so someone has asked, if I have two competent adult children, can they both be administrators of the estate? That's a great question. Yes,
they can be both. You can have co-administrators. They do have to do everything together pretty well.
There has to be agreement
on that, and they have, each step has to be done together. They're usually on decisions and signing documents. They both have to do it.
Now, what if is that applicable in every state?
Pretty well, that's in most states, yes.
What if there's a disagreement? Like, how does that get worked out? Does there have to be a third party that comes in and helps to mediate that, or what happens?
Well, if the executors can't agree, or the heirs or the beneficiary input, can't agree, that the court may have to intercede.
And that just gets more costly.
It gets more costly.
Way more costly. Okay, someone has a question of what methods can I use to have liquid assets available for my executor's use to pay for my burial expenses and other estate-related expenses?
So that's where I think having a bank account, at least one bank account that does have that paid-on death designation where it's immediately available, or that trust, the funds are in the trust, where those funds are immediately ready to be used. Because with the will approach of going to the probate, it takes a little bit of time to get that power. So having at least one account have some sort of paid on death designation.
That's great. What is a list of things that should be documented for your loved ones as a part of estate planning? So we talked about accounts, passwords, location of documents, obviously lists of different accounts. Like, what are some of those things that you?
Yes.
Like, give me whatever you think of.
Yes, of having the accounts, life insurance policies, the policies, any contracts, contacts, who is my financial planner, who is my CPA, all the different contacts, telephone numbers, things that just makes it easy where someone can just pick up and have that ready information to do the job.
Well, I also think too, just in a practical sense, like so often, again, this can feel really overwhelming sometimes for people who are listening, like, my gosh, I have to go make a list now. I almost think, is it helpful to just like start a list, and as you think of things, as you're going through, just start adding to it, like as you pay a bill, as you're in this particular account, like just start adding to the list.
Yeah.
So it doesn't feel as overwhelming at one time.
Yeah, and I think kind of get it in one spot. And so here, here's you're going to kind of find some things, and you can just add to it and just keep things organized.
Yeah. Like, how often do you find that people have not shared with their loved ones where these documents are?
I find that very, very often.
Really? So if you are that person, you're not alone.
You're not alone. You are not alone.
Make this easier for you and your family members.
So it makes it come up, if you don't have that information, a little bit of a detective work. Just trying to find all that.
Yeah. So again, it really is helpful to have it all in one place as much as possible. Can you amend an irrevocable trust, and how?
So irrevocable trust, that's what it means, irrevocable and amended. There are small ways to do that, but generally you cannot amend an irrevocable trust. That's something that is done.
I feel like we have covered so much today. Is there anything we haven't covered that you want to make sure that you say to people watching at home?
Well, we've covered a lot, but I guess best in summing it up, I think having everything in order and thinking through this is a great gift to your family. Like I said, it's hard for people to go through this, and having it all together makes it easier and a great gift for people.
Well, and I think, too, having some grace with ourselves. Like today, if you were sitting at home and watching this and thinking, oh my gosh, I have so much to do, like little bits at a time, like just take a little bit of a time and start to figure out where you need to be in the information that you need. I mean, you can also rewatch this webcast. It will be available for people to rewatch.
And there are some people who goes, well, I don't know exactly all that I want to do. And I said, well, let's do this part now. At least we feel comfortable with this part, and you can change and add to it as it comes, but at least get something in place and then add to it later on.
Where can people find, or what's a good place for people to look to find an attorney that can help with this?
So, there's a lot of online reviews of attorneys. I think talking to, getting referrals from some friends or other professionals, your CPA, financial, of getting someone that is well known and experienced in that area. All attorneys pretty well have their specialties.
I mean, again, Amy, we have covered so much information today. Thank you so much for just an invaluable discussion and lending your expertise to us.
You're welcome. I hope I have been able to answer at least some of the questions that your viewers have on mine, or at least maybe triggered to ask more questions.
Absolutely, absolutely. Thank you so much, Amy. All right, you can learn more about Amy at the links you see here. Thank you for joining us on today's episode of Grateful Life. You can view previous episodes and keep an eye out for information on upcoming episodes at brookdale.com/webcast. This webcast will be available to watch again at any time on the Brookdale YouTube channel. Please share this with your friends, family, caregivers, and anyone else you think would find it helpful. We will see you soon.